You are listening to Lone Star Community Radio on 104.5 KCZWLP Conroe and 106.1 KZCCLP Conroe and worldwide on irlonestar.com.
Hi, welcome to the Legal Connection Show. My name's Toni Collins, and I'm a licensed attorney in Texas, and we are a show that helps the community here in Montgomery County, and I guess on around the world if you're listening to it outside on the World Wide Web, answer and discuss legal questions that concern you. Citizens, and you can find us on our, you can listen to this recording on Facebook. It's called the legalconnectionshow.com. You can listen to us Tuesdays at noon live on 104.5 FM or 106.1 FM. You can also find us on YouTube, or you can go straight to the irlonestar.com website and be able to review this podcast later if you miss it today or you want to review it. So today, what we're going to go over is GEO Warrants, and I didn't know what those were. It has to do with your Fourth Amendment protected rights, and whether or not, if you're Googling something, the government can determine, invade your privacy, look at those records, and actually come to your door without a warrant and arrest you based on just searches that you make. And that can go from whether you were interested in something that was going on over, in China, the Wuhan virus, or uranium, or let's just say you believed that the building that came down over there in Miami was actually a terrorist act and not just a faulty construction, and you Google this. Well, law enforcement can actually get to your Google searches, which they're not supposed to do under the Fourth Amendment, without a warrant. And there's a lot of cases that have come down the pike that are upholding these warranted searches, and people are going to prison thinking that their private rights of just doing simple searches on and having stuff on their computer that nobody can see, and they feel like they're not harming anybody, they'll actually come to your door and arrest you. It's kind of a big brother thing. And we've had topics on the show before about Fourth Amendment rights and Carpenter versus U.S. and that kind of thing. But we're going to go over it in a sort of from a different angle today, and look at it from the cyber searches. And part of the intrigue to this subject to me is that my daughter works for Google and for Facebook, and the various internet. They're called ESPs. The different large corporations that we go to and do our searches and add our private content, not with the intent for anybody to look at it, but the target audience that we have, which may be our friends and family, or just for our own personal knowledge. Well, the government can get to those, and a part of her job has been from an international standpoint, she gets requests from Google Legal to actually go into your files, which are available to legal and their legal analyst, to determine whether or not they can respond to a subpoena or actually even a warrant by the government and turn over files. And so this is ongoing. And she said that she was really surprised at how much information. In fact, it's all of your information that Facebook and Google can access. And so we're going to kind of go there because there has been some cases recently where people have gone to jail. They've been indicted and actually convicted based on Google turning over information to the government. And the Fourth Amendment doesn't allow that. So we're going to kind of go over what your rights are and how you analyze that. And you need to think twice about the things that you're Googling or how you might protect yourself because of what's going on in society today and the technology that's available to the government and to other entities that may want your information. All right, so let's go over just the basic sort of a law school primer on the Fourth Amendment that you may have heard on all of those movies that they and shows and CSI. But we're going to go over it like for real what the actual law is today. All right, the Fourth Amendment reads like this, and because it's our Constitution, it is what any lawyer will go to if you believe that you've had your privacy has been breached by the government and your rights have been taken away. Okay, so this is it's so simple that our forefathers, over 200 years ago, wrote something so succinct that it's still applicable today. The Fourth Amendment reads, the Fourth Amendment, the right of the people to secure, and I'm quoting this, it's Amendment 4 to our Constitution in the Bill of Rights, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, it's easy for me to say, shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. All right, so that is verbatim the Fourth Amendment, except for my list and the things where I couldn't pronounce it. And here is just sort of the more easy to, and that was pretty easy to understand, but here's the sort of Americanized version. The Fourth Amendment originally enforced the notion that each man's home is his castle, secure from unreasonable searches and seizures of property by the government. It protects against arbitrary arrest and is the basis of the law regarding search warrants, stop and frisk, safety inspections, wiretaps, and other forms of surveillance, as well as being central to many other criminal law topics to privacy law. So the Fourth Amendment is supposed to protect you from all searches by the government and even persons unless they've got unless it's reasonable or they've got probable cause. All right. So here's a little bit more of the law before I start giving you some case examples of how this is being the end run game. They're getting around the government and people that want your information. Here is kind of in a nutshell the things that you need to know and the exceptions to the Fourth Amendment. The Fourth Amendment to the U.S. Constitution places limits on the power of the police to make arrests, search people and their property, and seize objects and contraband, such as illegal drugs or weapons. These limits are the bedrock of search and seizure law. So I'm going to talk about some of the issues, beginning with an overview of the Fourth Amendment itself, as I just now, but in a little bit more detail. And just to kind of add a little flavor to this, so you'll not be like falling over asleep while you're listening to me talk about this. It's here is an example of what can happen if your Fourth Amendment, if we didn't have a Fourth Amendment. Imagine waking up to the sounds of police officers furiously knocking at your door. Your recent delve into the evolution of uranium enrichment has made you the subject of FBI monitoring. And this could go so far as being your searches on Donald Trump, President Trump, or Joe Biden's son, the Wuhan virus. It could be anything that perhaps somebody in your locality or the government, or maybe that somebody that's got some pull, or maybe somebody that doesn't like you, has decided that they want to go into your business. All right. And we're going to focus on Google because that seems to be the entity that has such a grasp on so much of your data, because people do Google searches. They do more Google searches and they get more trouble with Google turning information over to the government than any of the other entities. So that's sort of our focus today. The Google search data that you used and the results you retrieved when doing your research have been subpoenaed by the government, and suddenly, inexplicably, you are under investigation. Just because of your curiosity and maybe wanted to be educated on what your position might be, because knowledge is power. On a given day, Google processes over 91 million searches based on search data entered by its users. Google maintains query logs, which provide a detailed account of search terms and their accompanying data results. Google also collects some identifying information that that a user's browser makes available whenever he or she visits the website. And all of this information is basically coming from the Google Privacy Center, a search engine watch.com, and information that's available to the public through the government Freedom of Information Acts. The log that is housed in your computer that Google is able to obtain because of the different Microsoft operating systems that we all get when we buy our computer that are built into it, and you basically sign away and waive away your rights to this information because it can be grabbed every time you turn on your computer. It's the user's internet protocol address that's assigned to your computer and this is how the government can get to where the computer data is housed. The browser type, the date, and the type of query, and one or more cookies that can be used to uniquely identify the user's browser. So this is how Google gets your information, because Microsoft can identify where you are by an IP address that's set up at your location in your computer. And that's just how they get pornographic information. When they go to these sites, they can go backward and find out, even if it's just an accident, if it's Pokemon, and like my kids used to do Pokemon all the time, and apparently sites they can manipulate that search and drive your child to a porn website, and then that stuff ends up on your IP address, and before you know it, you've done nothing wrong as a parent because your kid just was using your internet browser and accidentally happened upon these sites that have zeroed in on this, and now you're in trouble and you don't even know it, and you may be under investigation and not even know it. Considering the sheer volume of searches that Google runs per day and the growing utility of search engines such as Google in today's society, the possibilities and implications of such information being misused are alarming. So we're going to talk a little bit about the history of the internet search engine growth and a brief description of search engine mechanics, so you can kind of see how easy this is to get to. And then we're going to look at whether the data we provide to the internet search engines and the search histories are created as a result are protected under the unreasonable search and seizure of the Fourth Amendment. All right. Internet users retain a reasonable expectation of privacy when using search engines. I know I certainly do. I don't expect when I'm Googling information to defend my criminal clients, and I'm Googling stuff across the board about drugs I never even heard of that they're being accused of using or have been seized. I would not be surprised if I am under multiple investigations because I'm having to get information from the internet to be able to defend my clients. And I don't get a waiver just because I'm an attorney. And you may not either if you're looking at something for a loved one, a relative, or just because you're curious about something you read in the paper. Internet users retain a reasonable amount of expectation, similar to email communications, which are stored at fixed locations before reaching their destination, and as such, retain a justifiable expectation of privacy. The search term data we provide to search engines are also stored at fixed locations before search results are created, and as such, should be protected by unreasonable search and seizure. I mean, that's just what the Fourth Amendment says, but that's not what's happening. So, in a whole, just to kind of put it all into a package, the search histories internet users create as a part of their everyday business and activities should be protected from unreasonable searches by both the Fourth Amendment and it's called the ECPA, Electronic Communications Privacy Act, which we'll go over briefly. I mean, you should be protected, but I'm just going to tell you that just beware you're not, based on these cases that I was just reading about that have gone through the different circuits and up to the Supreme Court. By failing to protect the privacy of internet users when using a search engine, we risk damaging the consumer confidence in using the essential technology, and we undermine the integrity of federal law. Well, let me tell you right now, it is not, I don't see anybody giving up using Google to search for addresses and what have you. So there's very little you can do other than to be armed with your rights in case a police officer with a search warrant or an arrest warrant comes to your door, which they can. Okay, so here's just a little bit of background about the roots of search query subpoenas. In August of 2005, Google was served with a government subpoena demanding disclosure of 2 months' worth of search queries entered into its search engine and production of any and all uniform resource locators. Those are URLs. You see that terminology all the time. I didn't even know what that stood for, but when Google has the ability to access these uniform resource locators in Google's index that could be found by a given search query. So they have the technology to be able to put in URL data and pull everything that was searched. The purpose of the subpoena in this particular case was to aid the government's position in a different case, the ACLU, American Civil Liberties Union versus Gonzalez. All right. And several other plaintiffs in an action against the government upon the enactment of the Child Online Protection Act. So the ACLU was basically had a class action suit to prevent the government from being able to go on using the cloak of the Child Online Protection Act to get into your business. All right, and the Child Online Protection Act, their little anachronism is COPA, C-O-P-A. COPA protects communications by means of the World Wide Web for commercial purposes that is available to any minor, and that includes material that is harmful to minors. So COPA was enacted to protect minors. The purpose of COPA is to protect children from potentially harmful online communications. All right. The statute defines material that is harmful to minors to mean material that is either obscene or material that an average person applying contemporary community standards would find, taking the material as a whole, with respect to minors, to be designed to appeal to or designed to pander to the prurient interest, depicts or describes basically lewd acts, with sexual content, and those kind of things. So the act was to protect children, all right? But this act really sort of opened the door to allow the government to use that as a I don't want to maybe as a not as a conduit, but it was just for them to use as a cloak to get into it. It was a ruse to get into other information. Okay, so the ACLUs and other plaintiffs challenged this COPA because the First Amendment constitutional concerns. All right, that you are protected and you have certain privacy rights. The district court in the ACLU versus Reno granted a preliminary injunction with respect to enforcing COPA on the grounds that COPA is likely to be found unconstitutional on its face for violating the First Amendment rights of adults. After granting certiorari, the U.S. Supreme Court affirmed the preliminary injunction. So the U.S. Supreme Court was protecting our privacy and held that there was insufficient information that alternative methods of preventing minors from viewing harmful materials was any less effective than COPA. In order to allow parties to update and supplement the factual record to reflect current technology realities, the court remanded the case for trial on the merits and preliminary stages for Gonzalez versus Google. In other words, they were saying, and without me knowing much more about the case, that parents basically should take the responsibility to prevent their children from seeing this pornographic material and the material with sexual content, because we don't want the government to be Big Brother. We feel like the parents should be enough to be able to take a device away from your child, and maybe even teachers to be able to prevent them and to limit the usage with the different things that you can put on your computer to protect your child from seeing these things. Following remand, the government initiated a study aimed at testing the effectiveness of alternative methods of blocking harmful online contact to minors. The study was focused on testing, blocking, filtering software which the government contended was less effective for the proposed objective of protecting children than this COPA Act. To provide data for its study, the government served a subpoena on Google, the America Online, AOL, Yahoo, and Microsoft. The subpoena required a listing of URLs available to each company's users and the text of the user search queries. AOL, Microsoft, and Yahoo all produced the subpoena materials, but Google objected, which is great that Google objected. But Google purportedly treats the information it receives as part of search queries, as well as the method of searching the index and returning URLs as highly confidential. That may be the case, but based on a case that just came out in the U.S., the Sixth Circuit, you'll see that Google now turns over an incredible amount of information, and I guess maybe I don't know how they're so close in their relationship with the government now, but now Google does turn over quite a bit of information that they previously were holding out, at least to the public, was confidential. The government moved to compel Google's compliance. The initial subpoena to Google sought the production of electronic file of all available URLs to be located on a query on the company search engine. Following negotiations with Google, the government narrowed its request to all queries entered in a Google search engine during a 1 week period, which is really more fair because they said they were only doing it for a study. But I don't think that's all they were doing it for. They were collecting data for money. The love of money is the root of all evil. So you can always trace what the government's doing for in large entities if you can look to where the money's going and who would profit by this information. Finally, through the course of the action, the government further restricted the scope of the request so that it required only 5,000 entries from Google's query log, which would also be fair just for a study. Despite the modifications of the government request, Google maintained its objection and proceeded with the action. The U.S. District Court acknowledged that Google versus Gonzalez raised vital issues regarding the government's power to subpoena a third party, a third party's interest in not being forced to reveal confidential business information, and the interest of individuals to be free from the government surveillance of their internet use. The court found that the government did not demonstrate a substantial need for both the information contained in the sample URLs and the sample of the query text, which makes sense. It was just a study. However, because of the broad definition of relevance in the Federal Rule 26, the narrow scope of the subpoena, the court ordered Google to confer the government to confer with the government to develop a protocol for random selection and immediate production of 50,000 URLs. The court did not express an opinion on the privacy issue because the government's motion was partially granted such that only a sample of URLs were required for the production for this study. All right. And this was back in 2005 when this came up. Ultimately, now Google gives quite a bit of information. The court refrained from expressing an opinion on the Electronic Communications Privacy Act, but we're going to go over that in just a little while to show that really it's just a veil, a thin veil, because they can get to your information, and people are being sent to prison for up to 116 years. In U.S. Supreme Court versus Carpenter, that was a Supreme Court case that came out in 2018. While they kind of poked at our constitutional rights, in U.S. v. Carpenter actually went to prison based on the information that they got from these internet searches from the internet searches he did, and from Google's cooperation in turning over a private entity. I suppose you can call it private. Seems to me it's basically sort of government now, but because it's so large, it's a monopoly on your internet searches. But nevertheless, Google now turns over information. They turned it over in a number of cases, and people are going to prison for the information that that Google is providing via these warrantless now they're even warrantless searches of your ESPs by the private entities in the government. For a little bit of history on internet searches, and this may go back before some of you were born, but in 1990, a group of McGill University of Montreal students created what is considered the first internet search tool. And that's interesting to me because I remember 1990. I remember where I worked, and I don't remember using the internet at that point, but I do remember the government having a protocol, a test where the internet was used, and me being able to use my my basic commands on my little black and white computer that was the size of this desk. Basically, it was huge, but I could actually access the internet on a limited scale as far back as 1990. I remember it being available and me thinking it was really fun. Anyway, this group of students created something called Archie. And Archie was a script-based data gathering program which downloaded the direct listings of all the files located on FTP sites and created a database of file names. In 1991, a group of researchers at the University of Minnesota, lots of stuff going up north, released a document search and retrieval network protocol called Gopher. Gopher was followed by programs such as Veronica and Jughead, which searched the files sorted in Gopher indexing system and provided an index of menu titles and listings on thousands of Gopher searches. Once the World Wide Web became publicly available in August of 1991, which I recall that being about right, but not a lot of people knew about it, but they were excited to see this new technology, access to the internet increased exponentially, and internet search tool development expanded outside the realm of academia and industrial research. So kids that were born in 1988 or even in the 1990s, where now you're just, kind of flippantly thinking this has existed forever. I don't know a life without the internet. In my background, this did not exist. We had to go even, in law school to go to books to research all of these cases that were, you had to understand how to find them and go to indexes, and it was real difficult. Now, you can pretty much just ask Alexa, which was something that was so far removed from, it was like 2001 Space Odyssey. That was a movie that came out in 1969. Before we landed on the moon, a man made it to the moon. Technology's increased so fast and so exponentially. This is incredible. So, internet these internet searches. The law on it is still making its way through the system because it's still fairly new in the big scheme of our country and the laws that are out there that we can use as our sources to interpret the Constitution. Okay, in 1993, Mosaic emerged as the first web browser providing a graphical user interface, and along with it came Wandex, the first internet research engine. Wandex, W-A-N-D-E-X, was merely an index that captured URLs and was based on a MIT-created web crawler designed to track web growth. However, the first search engine that allowed users to search for any word in any web page with a simple user interface was named Web Crawler, and it was born in 1994, just as my daughter was, so they're the same age. Another research project also in 1994 resulted in the creation of Lycos, L-Y-C-O-S, which was the first search engine to determine context and relevancy when linking to websites instead of simple word matching. Lycos also provided users with prefix matching and word proximity in portions of pages. Arguably, the greatest benefit of using Lycos was the size of the document. The size of its document catalog, which reached 1.5 million documents by 1995. It's just so small in the trillions, and I don't even know what the words are that go beyond that, but trillions and trillions of data that's going through the internet now that can be retrieved so quickly. I could go on and on. I'll just tell you that with all of these different tools, I was curious to see how Google became the preeminent source and search engine. It looks like Yahoo for a while had one of the best search engines in 1994. It used search technology that provided hierarchical subject classified directories of web information. Between 95 and 2000, several other search engines made their market debut, while other were acquired or disappeared from the market. Now, importantly, in 1998, Google was launched by Larry Page and Sergey Brin. Google featured a simple user interface and a search technology that linked popularity and a method for objectively ranking web pages based on human interest to produce effective search results. By 2001, 2001 Space Odyssey, even though the movie was made in 1969, Google had grown to one of the most popular and prominent search engines. Advances in search engine technology are increasing efficiency by allowing greater data indexing without increased web crawling. Geocoding is another recent innovation in search technology. Geocoding matches search results to geographic locations such as street addresses, neighborhoods, and cities, which is actually what we're going to talk about today was GEO Warrants and how law enforcement, with Google's help, can determine literally where a cell phone is being used to try to find a person that may have committed a robbery or done something wrong. And if they get it wrong, then they have improperly indicted or created an investigation against an innocent person, which is what's been happening in some of these cases very recently. By the end of 1999, major search engines could index up to 2 million documents. And then it kind of goes forward with the trend and the ability for search engine data to be effectively produced to entities that request your information via subpoena or with a warrant through the government. And we know today that you can pretty much get anything on the internet. So I will just end with the search engine sort of history lesson with just know that basically anything that you do on your computer today can be found with a subpoena or warrant. It can get down to your IP address, your actual location, and what you're using on your phone. And it seems to me that they can even when your phone is off, they can get this information now. The technology has become so advanced. Okay, so back to your Fourth Amendment rights before we get into a couple stories that will just scare the life out of you about how the government and these private entities can get to your information. The Fourth Amendment protects your privacy, or should. This print is kind of small, so forgive me because I will be 61 this month and my glasses are no longer as effective as they were. The Fourth Amendment, we've already told you that basically it's the right of the people to be secure of the person's houses, papers, and effects against unreasonable searches and seizures. That should not be violated unless there's probable cause with a warrant. When does the Fourth Amendment, when it doesn't protect you, and this is important, the Fourth Amendment applies to a search only if a person has a legitimate expectation of privacy in the place the amendment in a place. The amendment offers no protection where in a place that you wouldn't expect privacy, which is typically going to be your home, your car, or your computer, which I believe that you should believe is private, because they are by definition not privacy issues. You have a legitimate expectation of privacy, and the courts have determined this, so you can do a legal analysis with it by using a two-part test fashioned by the U.S. Supreme Court to determine whether, at the time of the search, a defendant had a legitimate expectation of privacy in the place of things searched. And so the two questions are, did the person actually expect some degree of privacy? I would say with your private use of your internet at home, you would. And then second, is the person's expectation objectively reasonable? That is, one that society is willing to recognize. And I would believe that if you're doing internet searches, of course you would expect privacy because you're doing it, generally without somebody looking over your shoulder if you're not in a school setting on your own computer, believing that what you're looking at is not going anywhere, right? On the other hand, if an officer stops a car and this is an example, when talking to the driver happens to notice a weapon on the passenger seat, there's been no search under the Fourth Amendment, according to the law. That's because even if the driver somehow considered the passenger seat to be a private place, society isn't willing to extend privacy protections to a particular location, in this particular location. In other words, there's no objectively reasonable expectation of privacy with respect to a gun because it was in plain view. So if you're out in your car and you're driving around and you've got something that somebody can see when they look in, and by the way, I learned that you can't have the dark tint that you can't see in on your car, on your windshield because you couldn't see out, but on the driver's side, but you can have it on the other sides. Because we were looking at a car the other day where this guy was driving crazy. We looked to see who it was, but we could not see because it was completely blacked in. It could have been a 5-year-old for all we knew, but there was nothing we could do about it if we couldn't see in the car, and that's against the law. A good example of how this works comes from a U.S. Supreme Court case in which the court held that a bus passenger had a legitimate expectation of privacy in an opaque carry-on bag positioned in a luggage rack above the passenger's head. The court held that the physical probing by the police of the bag's exterior for evidence of contraband constituted a search subject to the Fourth Amendment limitations. All right. Private security personnel have at times outnumbered police officers in the United States by 3 to 1. And I'm only adding that because as a result, whether you're shopping in a supermarket or a pharmacy, working in an office building, or visiting a friend in a housing project, you might be more likely to be confronted by a security guard than a police officer. The Fourth Amendment doesn't apply to searches carried out by a non-governmental employee, like private security guards, who aren't acting on the government's behalf. So if someone hires a detective, they can search, apparently. For an example, assume that a shopping mall security guard acting on a pure hunch searches a teenager's backpack. Inside the backpack, the guard finds a baggie containing an illegal drug. The guard can detain the teenager, call the police, and turn the drug over to a police officer. The drug is admissible in evidence because the search was conducted by a private security guard acting on his own rather than at the officer's direction. And that's kind of where we're going with these internet searches. If the government's not asking for it, although if they're asking for it through Google, they're finding ways and loopholes to get to your private information because they're saying the government's not actually asking for it, or they're finding an exception to the law. Okay, so here are the exclusions. If it turns out that the police conducted an illegal search, does that mean that the criminal case is over? Not necessarily, but because consequences do exist. The exclusionary rule is this: if upon review a court finds that an unreasonable search occurred, and this would be out without a warrant or without your reasonable expectation of privacy, any evidence seized as a result of it cannot be used as direct evidence against a defendant in a criminal prosecution. So let me repeat that. If, upon review, a court finds that an unreasonable search occurred, any evidence seized as a result cannot be used. Okay? The principle is established in the United States Supreme Court in 1961, and it's become known as the exclusionary rule. And I'm going to sort of add in a real-life situation that if the police stop you for a DWI, for an example, and they ask you to step out of your car and to do and ask you for your ID, and they ask you to do a field sobriety test. They don't give you your Miranda rights, which is Miranda versus U.S. Supreme Court, or U.S. in the Supreme Court case. I believe it was 1964 in Arizona. It was Miranda versus Arizona in Miranda 1, and that's how the Miranda rule came in effect in 1964, saying that you must be read your rights but prior to any statements that you make under a custodial interrogation by the police, and it can't become admissible, and it becomes fruit of the poison tree, and it won't be admitted. And many times I've seen very recently in cases where the courts will suppress evidence in a DWI stop if the court has exceeded its reasonableness. I'm sorry, not the court, but the officer has exceeded its reasonableness in its search. And anything that you say after a certain point can't be admitted. So if you admit to drinking, 6 beers and admit that you were drunk and you have contraband in your car and all kind of things, but there was no reason for the stop, and or certain other things that come into play in this Fourth Amendment search and seizure motion to suppress, which is how they keep the data out, or a motion to dismiss, but usually it's motion to suppress first. if the court finds that the officer has exceeded his authority and violated your Fourth Amendment constitutional right, then they'll suppress this evidence. And the if an officer pulls you over and says that you're weaving along the road, and by their own observation, they thought that you were drunk, and so they arrested you. And when and they took you in, and you failed your sobriety test, and you admitted to, killing people and various other things. If the court views the video and determines that you weren't driving crazy, and anything after the point that you were stopped won't come in, they suppress that evidence, even though it would be in the public's best interest that you be arrested. It'll be suppressed, and I've seen that happen time and time again. But it's not. Usually, when you see the videos that they're playing to show, the police, the prosecutors are using, that the police have provided them with their police officer videos, their body cams, and their the car videos. They usually, you find out that they're not telling the truth, or they were weaving a little bit, or they didn't turn a blinker on, and it can't be suppressed. But maybe they can press something later. But so this is applied in many cases, and a lot of times, the data that's going to the evidence that has been collected improperly will be suppressed, and your case can be dismissed. And that happened to me in my own case, where I applied another Arizona Supreme Court case. It was U.S. v. Gant, and it was a 2009 case that didn't allow an inventory search to a car because there was no because the inventory search wasn't connected to the reason they were being stopped. It was an arrest under a warrant, and a car inventory search when somebody was already there to get the car wasn't necessary. My guy in this case had tons of contraband and illegal drugs in his car. I was able to argue to the judge, even after we had picked a jury, because they were going forward with this. The judge suppressed the evidence found in his car because the inventory search was not legal, and my client's case was dismissed because the government had no evidence, and he was facing 25 to life because he was a perpetual convicted felon. But the truth of the matter is, my guy really wasn't a perpetual convicted felon. He had sex with his 16-year-old girlfriend back down in the valley, and her father was a prosecutor and got him to commit to that, and he kept violating his sex offender requirements, which are really, really, really tough. And they were just after him. And so he really wasn't a perpetual, and he shouldn't have been in jail for something like that. He was 19 at the time he was having sex with his almost 16-year-old girlfriend. And so it was, kind of sad that it went down like that. And I was happy to be able to help him. But this goes towards your Fourth Amendment rights and how you can get evidence suppressed. And if you fight hard enough, justice can be done, at least in certain circumstances. Okay. Now, to this day, many commentators criticize the exclusionary rule that we just talked about on the ground that it unfairly lets the criminal go free because the constable has erred. But the rule's supporters argue that excluding illegally seized evidence isn't necessary to deter police from conducting illegal searches, which it is. You can't just target somebody to see you want to because you think you're going to be a do-gooder or a hero or whatever. I mean, I do want the police to protect us, but I want them to protect us from people that are actually committing crimes, not just for the benefit of putting somebody in jail and saying they're doing their duty. That's just unfair to us as citizens because it could be you. According to this deterrence argument, the police are less likely to conduct improper searches if the resulting evidence can't be used to convict the defendant. There are, however, exceptions even to the exclusionary rule. Okay, so don't hang your hat on that. Just be aware that you have rights and be cautious that you're being pulled over, or someone's knocking on your door with a warrantless search of your home because of your internet searches, because that's what we're getting out right now. They can still do this under these new cases that are coming out, and there's so many people that could be watching their internet searches, but you don't know if you've got some, ex-wife or, enemy or somebody that you worked with that's coming after you and has some friend in Google or the government that will do an illegal search of you and perhaps find stuff that you did do wrong and you didn't know about. So just kind of be aware of that. And I would be using all of that software that, deletes cookies and, your McAfee software for security, which, by the way, I think you probably all heard in the news that the man that created McAfee and had the patents, that the millionaire who had been under the microscope of the law since there was a death of a roommate at his house down in South America, he was arrested for tax evasion of some sort, or there was a warrant out, and he was extradited from a foreign country, and I can't remember which one it was. It might have been England. I can't remember. Recently, like in the last 2 weeks, to face tax evasion charges stemming from returns filed or not filed properly in 2016 to 2018, which is really nothing for this billionaire. And I guess he didn't want to face the what he felt was a witch hunt, and he committed suicide in his cell. I think it might have been Germany, wherever it was. Mr. McAfee killed himself, and it's just, really kind of a shame that it went to that. But it goes around, comes around. I guess he may have actually murdered somebody, and maybe, this was kind of why they were looking at him for the tax evasion purposes, like they did, Al Capone. They got him for tax evasion, as opposed to being the mafia leader and a gangster. Okay, so fruit of the poisonous tree doctrine basically says that the product of an illegal search generally is in admissible court, but so too is additional evidence derived from the initial search. The principle is colorfully known as fruit of the poisonous tree. If you ever hear that doctrine, the tree is the evidence that the police illegally seized fruit that was the fruit back at Adam and Eve that was poisonous, and our first sin, and is a second generation product of an illegal seizure. So both the tree and the fruit are typically inadmissible at trial. So just be aware that if somebody comes knocking at your door, say nothing, let them arrest you, get a good lawyer. You may be able to get out of it no matter what is on your computer. Just be very careful. Here's an example. Officer Wiley arrests Mr. Lowe, Mr. Hilo, for selling phony telephone cards. A judge rules the officer Wiley illegally entered Lowe's home and improperly seized a map showing the location where Lowe had the phone cards. Officer Wiley found the phone cards in that location because Officer Wiley obtained the map through an illegal search. The map and the phones are inadmissible. The phone cards are the fruit of the unlawful search. So be aware that the secondary information that's obtained through the illegal search is what's inadmissible. And that's like these Google searches. If the search of your computer is illegal, then anything they find on it is also inadmissible. That's how this all kind of ties together. The impact on defendants on a criminal case. Some defendants believe that if they can show that the search was illegal, the case must be dismissed. That's not necessarily true. If they can find the loophole to be able to let it come in as admissible, and there are loopholes. So, if the government can show that it was a private search, just like what we talked about before, where a security guard or a private investigator has provided the information to the government, then that would be the loophole. Now, so here is the question. Do geofence warrants violate the Fourth Amendment? And this is where the government gets a warrant to search, not even a warrantless search. They actually are saying, we want to look at your information, and we're going to get a warrant to look at your data. So we're going to look at something that the New York Times talked about last February when COVID started. Last year, a New York Times feature detailed law enforcement's use of a new investigative technique called a geofence warrant. Unlike traditional warrants that identify a particular suspect in advance of a search, geofence warrants essentially allow the government to work backward. These warrants compel a technology company, and so far, Google was the only one they were using at the time, to disclose and non I'm going to destroy this word, anonymatized location records for any devices in a certain area during a specific time period. After that, for certain accounts, the government may obtain additional location data and subscriber information, particularly in light of the Supreme Court's watershed decision in Carpenter, which is the 2018 case we discussed earlier. Geofence warrants present a host of novel Fourth Amendment issues. And here's an example. A criminal defendant accused of armed robbery is currently mounting the first known federal Fourth Amendment challenge against a geofence warrant in the federal district court in Richmond, Virginia. His is just the one they're discussing in this article. We have them in every circuit. This post packs briefings from the defense, the government, and the Google through an amicus brief on the motion to suppress in that case. The stakes of litigation are high. As Google reported it in its brief, year over year, Google has obtained a 1,500% increase in the number of geofence requests it received in 2018 compared to 2017. And so it's exponential. Every year, Google is getting more requests, and they're honoring them. And so this is what happened in this case. And then we're going to go about one that just happened like 2 or 3 weeks ago that's in the record again, where somebody went to prison for one of these geofence warrants. Around 5 p.m. on May 20th, 2019, a man with a gun robbed a bank near Richmond, Virginia, escaping with almost $200,000. Surveillance footage, and I'm getting the code from station manager Dick that I only have 5 minutes. This went by so fast. I'm just trying to alert you to how difficult, how your rights are being invaded, and how you need to protect yourself and be aware that someone could be knocking at your door, and for something that you had no idea that someone was just using your computer, and maybe even using a ghost IP address on your computer to do things, then you may be arrested because of it. So here's the example. Surveillance footage showed that the perpetrator held a cell phone to his ear before entering the bank. About a month after the robbery, state law enforcement officials obtained a geofence warrant from a state magistrate judge. The warrant authorized a 3-step process in which law enforcement could, without seeking further judicial approval, compel Google to produce increasingly detailed data on certain suspects. In the first step, the government requested Google to provide with its location records for any Google account that was associated with a device within 150 meters of the bank during a 1-hour window that included the time of the robbery, as well as 30 minutes before and 30 minutes after it occurred. As Google noted in its brief, this required Google to search across every existing Google account and then run a computation to determine which records match the time and the space parameters in the warrant. When there is a strong GPS signal available, Google explained, a device location can be estimated within approximately 20 meters. After about 2 weeks, the warrant was approved. Google disclosed the information, and it had 19 accounts that had been within the 15 meters, and they turned over all this information. The second step was the government requested another round of information with more specified data. Finally, at the third step, the law enforcement requested Google reveal the subscriber information for the account above. They found 2 different people. They got warrants for their arrest, and now, based only on the Google searches, these people have been indicted and are facing felony robbery charges. So was there a Fourth Amendment search? The parties dispute whether the data obtained from Google constituted a Fourth Amendment search. In other words, while the government contended it could have obtained the Google data without even having a warrant, defense counsel argued that the government's actions implicated Fourth Amendment protections, which of course they did. For both parties, this analysis turned on the question as to how Carpenter applied. In Carpenter, the U.S. Supreme Court ruled that access to at least 7 days of a person's cell phone site records was a Fourth Amendment search was a violation because a person's legitimate expectation of privacy in the record of his physical movements is a privacy expectation. And because I only have 5 minutes, I'm going to go on to tell you that in Carpenter, while they ruled that you have an expectation of privacy in your cell phone records that were obtained through a backward search for Carpenter, he was still convicted on other, quote, for other reasons, to 116 years in prison for his part in what he was found against him. And gosh, I need to find that particular case, which is Carpenter. But basically, it didn't matter that they found it; they still got around it. There was a loophole. There's a Fourth Amendment case that was discussed in the Law Journal that says that the Sixth Circuit was the latest federal appellate court to reject the argument that opening a file that has been hashtagged to child pornography constitutes a warrantless search under the Fourth Amendment. The contraband trapping technique at stake is a conceptually simple electronic communications service providers, ESPs, filter files that pass through their servers by matching each file a hash value against its database on a hash known as for illegal pictures was valid. A hash value, they got to their ESP address. They went through Google to find the ESP. They were able to determine the IP address, and this person has basically found that despite his argument, the court considered whether Miller's defense, the guy's name was Miller, that a detective's viewing of the files amounted to a Fourth Amendment physical trespass. The court analyzed the detective's opening of the data files to colonial authorities' intrusion in a person's personal effects and papers, a practice that the First Amendment clearly aimed to curtail. But here, Google, not the detective first, matched the hash value, the Google legal assistance, which is what my daughter does, and the private search doctrine applied. So because Google allowed its legal assistance through a request of the government to first look at whether its pornographic material existed. They determined that the information obtained through the Google search to the IP address and getting to this information was not inadmissible. It did get admitted. It was evidence, and this man went to prison for who knows how long for the search on his computer. So the bottom line is you have to be really, really careful. Anything that's Googled from a computer basically can and will be held against you, and you don't even know it's happening. You don't even know who's using your computer or your cell phone. And when they do use your computer or cell phone through these searches to find you, they might find other information just like in the Watergate search that they didn't expect to find that may bring you down. So I'm being told by Station Manager Dick that I need to wrap it up. You can go to our website, which is thelegalconnectionshow.com, our Facebook page. I'm going to have some links where you can look up these cases. You can look at your Fourth Amendment rights and how you're affected by them. So we're going to sign off for today. Please stay tuned. Next week, we're going to go over some more Fourth and 14th Amendment violations. And most importantly, remember to serve God by serving others. We will see you next week. Thanks. Bye.